On September 25, 2001, the United States government granted a patent. Not for a drug, not for a circuit, not for a process. For a machine whose entire purpose is to kick you in the backside. United States Patent 6,293,874. The official title in the dry language of the Patent Office reads, a user-operated amusement apparatus for kicking the user's buttocks. You bend forward, you grab a crank, you turn it yourself, and a set of rotating arms with soft shoes on the ends paddles you, again and again, for your own amusement and the amusement of anyone watching. This is a real patent. It passed examination, and the strange part is not that someone drew it. The strange part is that the law had no grounds to say no. Let's read what the patent actually protects, because it is more carefully built than you would expect. The apparatus is a platform that folds at the middle with two upright posts. The first post holds a hand crank mounted at a height that forces the user to bend forward to reach it, which conveniently presents the buttocks toward the second post. The second post holds a set of elongated rotating arms tipped with flexible extensions set level with the user's backside. Turn the crank, and a drive train spins the arms, and the arms do the kicking. The whole thing folds into a self-contained package for storage and shipping. That is Claim 1. Notice what the inventor claimed as the point of the device: amusement. Not exercise, not therapy, not punishment. Entertainment for the user and for onlookers. And here is the question that should bother you. To get a patent, an invention must be new, it must be non-obvious, and it must be useful. New and non-obvious, fine maybe, but useful. In what sense is a machine for kicking yourself useful? The answer to that question is the whole file. Because the word useful in American patent law does not mean what you think it means. For most of American history, useful carried a moral weight. In 1817, riding circuit in Massachusetts, Supreme Court Justice Joseph Story wrote the rule that would govern for over a century. To be patentable, he said, an invention must not be frivolous or injurious to the well-being, good policy, or sound morals of society. A new invention to poison people, to promote debauchery, to help a private assassination was not patentable. The law would not lend its protection to the useless or the immoral. This was called the moral utility doctrine, or beneficial utility, and for generations it gave examiners a reason to say, no, this thing serves no real benefit. This thing is a trick, this thing is frivolous, denied. A machine whose only function is to kick you would have been an easy target. It does nothing. It builds nothing. It is, by any plain reading, frivolous. Under Justice Story's rule, an examiner could have shown it the door. But Story's rule did not survive the 20th century. Courts grew uncomfortable with patent examiners acting as judges of morality and social worth. Slot machines got patents. So did beverage dispensers built to fool the customer about what was inside. Piece by piece, the moral filter was dismantled, until a single appeals court took the last of it apart. The case was Juicy Whip versus Orange Bang, decided by the Court of Appeals for the Federal Circuit in 1999, the court that hears every patent appeal in the country. The invention there was a drink dispenser with a display tank of fake liquid on top, designed to make customers think the drink came from the pretty tank when it actually came from somewhere else. A lower court had killed the patent. Its only purpose was to deceive, so it lacked utility. The Federal Circuit reversed, and in reversing it, it buried Justice Story's doctrine. An invention is useful, the court held, if it is capable of providing some identifiable benefit. The threshold is low. The fact that a device fools the public, or merely entertains, is not a reason to deny it a patent. If people want it, that is benefit enough. And the Patent Office wrote the same logic into its own examiner's manual. A utility rejection may not rest on the ground that an invention is frivolous, fraudulent, or against public policy. Read those two rulings together and the butt-kicking machine stops being absurd and becomes inevitable. It was granted in 2001, 2 years after U.S.C. Whip. Amusement is an identifiable benefit. The device does exactly what it claims. It is new, it is arguably non-obvious, and under the law as it now stood, it was useful. The examiner had no lever left to pull, so the patent issued. And then nothing happened. No company licensed it. No product shipped. No one was sued for building a rival kicking machine. Roughly 4 years after it was granted, the patent lapsed. The inventor stopped paying the maintenance fee, and the government let it expire. It is now public domain, free for anyone to build, which no one does. By the only measure that matters in commerce, it was worthless. But that is exactly why it is in this file. Most patents are not weapons and not fortunes. More than half of all patents are abandoned before they run their full term, because the owner decides they are not worth the fee. The butt-kicking machine is the pure case, a perfectly valid, perfectly granted, perfectly useless patent. And the office had a 1909 spanking machine on file as the closest prior art, a fraternal lodge initiation device that shocked and paddled its victim, and granted this one over it anyway. 92 years apart, the same flexible paddle, the same logic. If it amuses, it qualifies. That is the doctrine underneath this file. We tell ourselves a patent is a mark of worth, that the government examined this thing and judged it valuable. It did not. It judged it new, non-obvious, and capable of some identifiable benefit, and some identifiable benefit is a bar low enough to step over. The law stopped asking whether an invention deserves protection and started asking only whether it works as described. A machine for kicking yourself works exactly as described, so it earned the same certificate as the telephone. The patent system does not measure importance. It never promised to. Next time, a man who patented a way to swing sideways on a swing, and what the patent office did when the public found out.